You're welcome back. This is Newsfile, it's your most authoritative news analysis platform, and here on Newsfile, we put Ghana first. And a guest who have been helping us and will be helping us to continue with the discussion, the Honorable Joseph Dindiok-Penka, former Deputy Attorney General and Deputy Minister for Justice, former MP for Timpane, Inusa Fuseni, former ranking member, Constitutional, Legal and Parliamentary Affairs Committee of the 7th Parliament. He was former minister, and he is a former minister. And Martin Pebu is lawyer and activist. There are a few other people who will join us to look at the issues that we are canvassing for you. Just a few of your comments. Paulina Kranchi says, Penka says the security agencies can't get to galamsey areas when journalists can get there. Politics can cloud people's minds so much that they speak anyhow. I think he gave a context to it. DKS Francis says Erastus Osaridonko has fought illegal mining than the entire government. He has exposed it than the entire government. Kwame Nkrumah says, what Erastus is reporting is 100% accurate. I used the Abuabo Ayamfure bypass even up to Dieso last week, and I was shocked to see hundreds of people mining by the roadside as if they were just farming. It was terrible. Nana K said top government officials are deeply involved, of course. That is why people are bold to do what they are doing. Your comment ties in Dr. Clement Apak, MP for Bulsa South. He says, how can we fight galamsey when people at the presidency are alleged to be involved? These boys and girls in the field are working for financiers and their political beneficiaries. These guys can't buy excavators. Of course, we know that. They can't buy even some of the shovels that they hold. Can't buy excavators, champagnes, the mercury, etc. As long as those we pay with our taxes to protect our environment and resources, including our forests and water bodies, are beneficiaries of doing the opposite, the situation cannot get better. What we need is a true citizen rebellion against the corrupt and compromised officialdom. I support that any day. It's the only way, because officialdom is compromised, including government officials, agency staff, and elements in the security agencies. Right, that is clearly noted. Edmund says, my brother, I hope you are well. I'm watching you and I'm weeping for our motherland. I share in your pain and depression. Why, Ghana? Why? Yeah, just this other one. You don't identify yourself, but you say that the docility and gullibility of Ghanaians is sickening. If the president said he put his presidency on the line and evidence available shows people around him are culpable, Martin Pebu has called on Ghanaians to force the president to resign. What are we seeing? Insult upon insult on his person. We are comfortable looking on. Sad. All right. That's where I'll pause the messages. But my production has just shared one more. Nana Yao says, President Akufo-Addo has really disappointed us. Being in his last term, he is the best person to fight this galamsey menace since he doesn't have much to lose in terms of re-election. Let's really hope that he will get back on this subject and fight it head on. Promise Domevi says galamsey has defeated the president and his vice. The destruction of our environment is unbelievable, and the effects will forever hang on the necks of this present government. Well, it's been going on for how long? So I think it's only good to be fair to the facts, isn't it? And finally, you say there is other unseen impact of galamsey, which nobody talks about, and that's the ecological impact of galamsey. Well, we talk about it. As a molecular ecologist, I know we can lose or have probably lost vital, beneficial organisms that are essential for the maintenance of ecological balance, loss of which could result in an ecological catastrophe. Thank you all so very much. Now, let's go to begin with our next issue that we are seeking to canvass for you. So, as you know, I'm going to begin by reading a statement. And this statement was issued on October 26, 2020. It's titled, CSOs Go to Supreme Court Over Auditor General Daniel Domelevo's Forced Leave. I'm reading from the CDD Ghana website. It says the undersigned civil society organizations, CSOs, represented by our lawyers, have today, Monday the 26th of October 2020, filed a writ at the Supreme Court challenging the June 29, 2020 directive of the President that has sent the Auditor General, Mr. Daniel Domelevo, on involuntary leave since Wednesday, 1st July 2020. The President has appointed Mr. Johnson Akufo-Addo, an officer of the Auditor's Audit Service, to act as Auditor General during the 167 working days that the Auditor General is supposed to be away on forced leave. It will be recalled that on the 7th of July 2020, a coalition of CSOs called a press conference in response to the President's action and issued an appeal to the President to rescind his directive to the Auditor General. The coalition of CSOs, which included the undersigned organizations, expressed grave concern over the constitutional and governance implications of the President's action. Both the International Organization of Supreme Audit Institutions, INTOSAI, and the English-speaking section of the African Organization of Supreme Audit Institutions, AFROSAI-E, also implored the President to reconsider his decision. We indicated at the July 7 press conference that we would consider recourse to legal action to defend the Constitution and the independence of the Auditor General should it become necessary. We had hoped that the President would reconsider his decision in light of the deleterious effect of his action on public accountability and the fight against waste and corruption in the management of public finances. Unfortunately, that has not happened. Instead, certain developments since the Auditor General was forced to leave his office have only gone to worsen the situation, leaving us with no option but to seek the intervention of the courts. It is our fervent hope that through this legal action, we can safeguard the independence of the office of the Auditor General and all independent constitutional offices established under the Constitution of the Fourth Republic, so that they can discharge their lawful mandates effectively without fear or favor, and thereby play their respective part in our collective effort to build and strengthen the pillars of constitutionalism, checks and balances, and accountability in Ghana. And the CSOs are: 1. The Ghana Center for Democratic Development, CDD Ghana, Ghana Integrity Initiative, GII, Citizen Ghana Movement, Africa Center for Energy Policy, ACEP, Parliamentary Network Africa, Pimples Bites, Media Foundation for West Africa, MFWA, Send Ghana, and One Ghana Movement. Signed. Thank you very much. Now, let's begin with the lawyer who was leading the onslaught in court. Martin Pebu, thank you very much for your time. Hello, Martin.
Yes, hi, Sam. Good morning.
Good morning. Great. Great to have you. Congratulations for a good job done. But citizens are asking very critical questions. Your reliefs that you were seeking from the court included to prevent the president from doing what he had done, so that Daniel Domelevo will not be on forced leave, not to talk about continuing to constitute a removal from office or retirement. So, did you get what you sought?
We didn't get all, And when I say we didn't get, you are inclusive. You are part of the legal team. So is lawyer Isankuma, Professor Prempe, Dr. Kujo Asante, both of CDD, Kofi Bento, Nick Opoku, etc., Corey and Co. So all of us inclusive. We didn't get all, but like we say, from the Bible to our culture, half a loaf is better than none. And look, I must say, Sam, this particular brief was such a difficult one. I was really scared that we're going to lose the case, right? Because that this is a frontal attack, really, really frontal, a real frontal attack on the president's, his governance system and everything. So I thought we were not going to, win. But the Supreme Court has shown that, yes, they really have, excuse my French, the balls to do it. So on this occasion, we will allow the Supreme Court, we will commend them for a job well done. And earlier in the day, I'll say that Justice Doche had referred to our calling them unanimous FC. That name is rich them, they know it. So when he was doing Sremsai's case, a case in which you are even one of the plaintiffs, right? Okay. The COVID restrictions case.
Please stop exposing me.
you are one of the plaintiffs, right? You are Professor Tia. So in your case, the COVID restrictions case, when he finished, then he told Sremsai, so today when you go out there, I'm sure you are not going to call us unanimous FC in a derogatory manner. Yes, that's what Justice Doche said. And it was good. I was happy that, they refer to it. People are criticized, and they are saying that, look, we can take criticism, okay? We like it because it helps the way.
Yeah, people like you, people like the names you have mentioned, Ace and Kuma, they don't hit the court without faith, beyond faith, without being convinced on the point of law they are making. So I don't know why you seem to suggest that you were not too sure. But the point is, Ghanaians are asking, now what? Domelevo has long been asked through extrajudicial means. The Supreme Court said the president erred. How many years after the fact? So what?
Oh, Sam, yeah. This one there, you've caught me. I thought, I'd given my promise that I was not going to talk about the case frontally, except to laud the actions of the CSO, CDD, Ghana Integrity Initiative, One Ghana Movement, all the other organizations coming together. I thought I was going to limit myself so that I will let other lawyers talk about the merits, so that today I'm like some magnanimity.
Okay, so I've asked you a specific question, answer it. And I am clearly aware that one of the judges said you shouldn't go to the media and comment about it. I don't think there's a constitutional basis for that kind of order to you. It's a void order to you. It's your discretion to do what you have to do. The court is functus officio after it has given its judgment. And in fact, when you are commenting and you are not commenting contentiously, you are exercising your constitutional right, and nobody can take that away from you, my friend.
Oh, Sam, no, you're a strong man. Yeah. So middle of the road, yes, the Supreme Court is done a good job on this occasion. So, I'm just so overwhelmed by what they've done. Yeah, so if we say so what, and we are grateful to their lordships, okay? So I'll do middle of the road. Yes, you see that going forward, the decision is landmark because it's beginning to chart a new path. Because that, Sam, by this one decision, we can't just say, so what? There are 7 constitutional, independent constitutional bodies, right, in the Constitution. So with this decision on the Auditor General, it means that impliedly it's going to affect all the other 6. So if we mention, so we are looking at, apart from the Auditor General, we have the Judicial Service, we have the Lands Commission, Almighty EC, the National Media Commission, BOG that couldn't hold that was spineless, and last year, financed the government with about $40 billion, which helped to spike inflation. So this decision too will help BOG in its independence. You can check the IMF report where the IMF berated the BOG for its weakness. It couldn't hold its own against the government. So this is a decision that will help. So it means that we are helping to cut back on the autocratic, tendencies of our presidents. Because that's always been the bane of our democracy, that we've given too much power to an executive president under Article 58 and Article 57. I know that's largely to blame for a lot of our problems because, this constitution was made, from my understanding, Professor Hoy and Co., to appease J.J. Rawlings. So as soon as J.J. Rawlings was out of the picture, we had to take steps to do a new constitution because that's what I believe, what is being said, that it was basically to appease him. So you see a lot of the powers going to the president. So if Rawlings was no longer in power, there was a need. And I'm sure that's why Professor Mills took the initiative to do constitutional review. Okay. And what have we done with it? So whatever it is, this Supreme Court decision is a landmark decision, is going to reshape our constitution to check the executive president.
My last question to you before you take a breather and then I go around and come, because we have to come back to you later, is a question that members of the public are asking. Are they justified in asking that question? That one of the grounds for removing the president from office is that he has breached the Constitution. In this situation, is there consequence? Has he breached the Constitution, and is there a consequence that should flow from it?
All right. Sam, this is an ambush question. I wish I'd been given this question maybe 24 hours.
It's all over on social media. You should have seen it.
All right.
And known that I will ask it.
Breach of the Constitution. Because I come from the background of having held a full demonstration last year calling on President Akufo-Addo to resign, you can imagine that straight away my biases would be to say yes. But on the other hand, too, I think this is not the first time, a certain government or a certain president has lost, and this one, yes, is the certain president who has lost the case, has lost a case in court. So quickly, my mind goes to the 31st December case. President Rawlings used government funds to celebrate 31st December for quite a number of years, right? And so when the Supreme Court held in the MPP versus Attorney General, that's the 31st December case, that the use of public funds to celebrate the 31st December coup was unconstitutional, I don't think there was much of any argument that Rawlings then had to be impeached. Okay. I'm not saying it is right, but I'm just saying that, so that's why I said this kind of question, I need some time to reflect.
All right. Okay, hold on and take a breather for us.
Let me also mention something.
Yeah.
Let me mention, I think also that how about the argument that constitutional decisions usually take a prospective effect. So this interpretation takes effect from the 31st of May. So I don't know if we can use it to apply.
Well, the man on the street, and I'm coming to Inus of Sin to begin with in the studio. The man on the street says, I'm watching Supreme Court decisions. In one decision, they have said Yachik Singh, for one reason or the other, was unlawfully elected. So he never existed. He has never been in parliament, really, in the face of the law. And the consequence has followed. The consequence is that his name should be expunged from the records of parliament. He loses his seat. There's going to be a by-election. So people are now extrapolating and asking, so this one, what is the consequence for the president's wrongful conduct in extrajudicially removing the Auditor General and then bringing in another, in the wrong way?
Well, I think that you are perfectly right in stating that the citizens are asking for an impeachment of the president. You see, you have a president who swears an oath of office. The oath of office says that he pledges or swears to uphold, and you can read the full text of the oath.
No, you go on. You are going. Just
and
making sure that you are quoting it right.
Yes. He upholds the Constitution and laws of the country. And here we have a president who, as a lawyer, the president should have known, right, at the time that he was taking the decision, he was treading on the verge of unconstitutionality. I mean, if you read Dua Ajiman's case, I mean, you come to the conclusion that Dua Ajiman was held to be a public officer. At Article 199, you can dismiss a public officer for I mean, want of better word, for the performance of his functions. I mean, you cannot be capricious in dismissing a public officer. The facts of Domelevo's case lend credence to the fact that the letter directing him to proceed on leave was consequent upon his attempt to audit, to hold public officials, and particularly government officials, accountable. So when you put all the circumstances together, and you wrote at that time that was a constructive dismissal. I mean, and even immediately after his removal or the directive that he should proceed on leave, they brought in an acting Auditor General who the next day cleared the Minister of State, or at that time Minister of State, because he was senior minister, now subsequently senior advisor to the president, of any wrongdoing. So you can see the nexus that this person was simply removed malafide. I mean, the president had bad faith in removing the Domelevo.
But is it legally tenable and sound to say that on the basis of the president's oath that he took, that he has broken the oath in which he said he will be faithful and true to the Republic of Ghana, and that he will at all times preserve, protect, and defend the Constitution of the Republic of Ghana, and that he says that should I at any time break this oath of office, I shall submit myself to the laws of the Republic of Ghana and suffer the penalty for it. This is the basis where some are making this claim. And I'm asking, is this legally sound that a president will take advice? Because we know that's what presidents do. Take advice all the time, they take steps. Advice or an action which he believes to be correct, then it is later invalidated by the court. Is that a breach of the Constitution? Is that a violation of his oath?
We are not holding his advisors vicariously responsible for the wrong advice they give the president. And the president must always know that the buck stops with him. And that if you are advised, based on previous decisions of the court, to sack an Auditor General, whose office is a creature of the Constitution, then as a president, you must think twice, especially when you have sworn the oath of office to protect, defend, and uphold the Constitution. And when you have said that if you break the Constitution, any provision of the Constitution, you submit yourself to the laws of the country.
I am president. I am activating the Constitution in belief that I'm doing the right thing. A court disagrees with me. Does that mean I have breached the Constitution and must suffer a penalty for it?
Well, you think that only the court believed that he had breached the Constitution? People believed that what the president did was a breach, a fundamental and violent breach of the Constitution. They drew the president's attention to that. The president was adamant. In fact, when Domelevo himself drew the attention of the president to the fact that he was breaching the Constitution, it attracted the eye of the president. He escalated his leave. There is impunity. I'm actually waiting to read the judgment, whether the court will not describe that act as an act of impunity. Then proceeded on leave, barricaded his doors. I mean, what again do you think?
The president had lawyers who were advising him. Domelevo also had lawyers who were advising him. So if the two disagree...
So who were advising the CSOs?
And they also had their lawyers.
So you know, there was unanimity. I mean, in the public. And many people were taken aback. And I think that this is a good case where we should hold the president responsible.
So anytime the president takes an action, and the action is found to be unconstitutional or in violation of some law in this country, it means he has breached his oath.
He must suffer the penalty.
He must be subject to impeachment.
He must suffer the penalty for that. He must suffer until we begin to hold our presidents responsible, accountable, and not give excuses for their acts of impunity. Then we are not going to make progress. That's why I don't think that this decision must be prospective.
Will that be different from ministers and state functionaries breaching the law here and there, police officers doing wrong, ministers and their deputies and all that, signing contracts, bringing us judgment, debt,
that's not different. That's not different. Ministers of state, what do we do? The Constitution says we put them to a vote of censure. So they cannot breach the laws with impunity. So Parliament is the institution that passes the laws. And so when the minister breaches the law, you bring him to Parliament to answer.
Is the test not willfulness in the conduct?
There's no willfulness.
It's willfulness.
Why? Why willfulness?
It's willfulness.
What willfulness?
Yes, let's hear you, Penka.
It's not willfulness.
You see, otherwise the law will be upset.
First of all,
completely upset.
What's willfulness?
You see,
when we say something is willful, it means that it is intentional.
That you know that this is
willful. It's intentional. Yes.
But he was doing it.
He knew that. He knew that
he was right.
So in fact, he was willful and reckless.
Okay, let's see if the Supreme Court will say that. Yes, Penka.
Samson, 30 seconds. I'm going to make reference to something. On the 9th of April 2009, this letter was written at the office of the President. His Excellency J.E.A. Mills. Accumulated leave, Mr. Edward Duajima. The records show that you have accumulated leave of approximately 264. Hold on.
How could you have not expected this? Please, let him talk. Yes, go on.
No. I'm saying that this letter is in the public domain.
Yes, so let him read. Let him read. Go ahead, please.
Go ahead.
It's just a few lines. Go ahead.
I am directed by His Excellency the President of the Republic of Ghana, John Evans Atta Mills, to request that you take the said leave with effect from Wednesday, April 15, 2009. His Excellency further directs that you hand over all matters relating to the Office of the Auditor General to Mr. Richard Korte, Deputy Auditor General, who is by a copy of this letter requested to act as Auditor General until further notice. I'm drawing your attention to something. Now, on the 29th of June 2020, accumulated annual leave, Mr. Daniel Yao Domelevo. According to the records available to the office, you have accumulated annual leave of 123 working days, and that's directed by the President of the Republic, Nana Addo Dankwa Akufo-Addo, to request that you take your accumulated annual leave of 123 working days, effect from Wednesday, 1st July 2020. Now, question, to the best of your knowledge, belief, or both, is there any court order or declaration that declared that what His Excellency President Neil uttered was unlawful and unconstitutional?
What question is that?
Wait.
No, I want to know.
Question to himself. So
yeah, so
is it a rhetorical question?
Yeah, rhetorical.
Okay.
You should be answering.
My answer is that none. That specific letter was not challenged in court.
It was challenged.
Hold it.
PCRPO for it challenged.
No. I'm talking about. I know of the PCRPO for its case.
So
I'm talking about the effect of this letter.
The consequence of the letter.
The effect of the letter.
The consequences of the letter was challenged in court.
Namely that.
Yes.
When this particular letter was written to Joe Ajima and he proceeded on leave, the question I am asking today is the declaration that was made recently with respect to the proceed on leave letter by His Excellency Nana Addo, and the fact that a declaration has been made by the Supreme Court that that particular directive or letter was unconstitutional, specific. I'm saying that precedents guides governance. And so if precedent guides governance, and His Excellency the President in his judgment wrote this particular letter and said proceed on leave, and which has now been declared to be unconstitutional. And at the time of writing the letter, His Excellency the President was exercising his executive power, which is given to him by the Constitution. And he did it knowing very well in him that what he was doing was right, and in consonance and on all fours with the Constitution, which has later been declared null and void. Are you able to establish that at the time of writing this particular letter and asking the person to proceed on leave, the President was deliberate and willful and knew that what he was doing was unconstitutional and went ahead to do it.
How and at what
point? Are you able
point?
to establish that?
How and at what point do we determine judicially that a conduct of the president is in violation of the Constitution?
I mean, if you put it before the court makes a pronouncement.
Yes, so the court has done in this case.
Yes. So I'm saying that the court's pronouncement will now guide us.
Without consequence.
No, but the court, you see, one thing I have to state also is that, unfortunately, all three of us are lawyers. You know that there have been landmark cases in this country that we go to court for just declarations, after that we go celebrating, and no consequential orders are made. Salah is one. And other cases which have followed. So in this particular case, it was for probably the plaintiffs to seek certain reliefs. And you remember that...
To seek a relief for the impeachment of the president?
No, not impeachment of the president.
No, they are talking about reliance on the judgment that the president acted unconstitutional. He was wrong. On the basis of that, they say he has breached the Constitution. So, once he has violated it...
And the point is this. Again, you know, if there is a breach, and you want to trigger the process of removal of the president, there's a process.
That's correct. Yeah.
There's a process. And you also need certain numbers, even in parliament.
No, but what we are interrogating here now is that,
and
is this a basis for triggering impeachment?
My position is that it is not.
Okay.
And I have stated the reason why it is not. I'm saying that it must be willful. Because if I say that, for example, I acted in good conscience and I acted in manners that was in the interest of the country, I did not actually have in contemplation that my act will be unlawful at the end. And remember that it is only the Supreme Court that has the power to declare that your act is unconstitutional. So after litigation, they have declared that the act of the president is unconstitutional and etc. When in fact, and in belief, at the time of actually writing this letter, he was convicted that what he was doing was in conformity with the Constitution. So you cannot establish that willfulness. So I'm saying that it is not the basis. It cannot be the basis to trigger the removal of the president.
Is it
but if you do, then of course you must comply with the dictates of the Constitution.
Is it important to, is this noteworthy that, well, this is a civil process after all. So if there's no pronouncement on the back of it, that's where it ends.
That's where it ends.
So when will you ever get the president pronounced by a court? And that pronouncement can be used as the basis for him breaching his oath and breaching the Constitution, and therefore has to suffer the penalty for it, which is what he swore to. Because the president, whilst he's in office, is not even liable to a suit. He can't be prosecuted for any crime or anything. So when will we ever get a court make a pronouncement that affects the president while he sits in office?
It's very interesting because of the constitutional architecture. And again, I heard Martin say it, and I agree with him, that if you look at the transition from the military junta to civilian, we did some concessions in the Constitution in the name of inviting democracy.
Right.
We did some concessions. So probably we need to have a take at the Constitution if we have to actually actualize what we intend. Otherwise, what we're going to have here is that in the end, you are going to put this in remember that it's going to go to Parliament if you want to go to impeachment processes and all that.
Right.
And when you trigger it there, the debate will be carried out.
So, Samson, can I just rebut?
Just briefly, because I need to make progress.
I've listened to this logic of the argument of inviting Joe Ajiman to as a rationalization strategy for the decision of the Supreme Court. Joe Ajiman went to the court. Joe Ajiman's removal was said to be legal. The circumstances of Joe Ajiman are totally different from the circumstances surrounding Domelevo. It will be a stupid argument to try to equate Joe Ajiman's removal with Domelevo's removal. The president's conduct was willful to the extreme because his attention had been drawn to the potential unconstitutionality of his act. And he then acted with impunity. He decided that he would ignore the fact that his attention had been drawn to the unconstitutionality. A president who was intending to leave by his oath of office would have paused to look critically at decisions of the court and to advise himself on what to do, knowing very well that it has consequences. 3, constitutional matters, most constitutional decisions are declaratory decisions.
Right.
And because they are declaratory, when they so declare, consequential actions can follow. The court itself can make consequential orders, or the victorious party can take consequential actions.
Okay.
And so that is what declarations do.
So
when the court said the president had acted unconstitutionally, then the consequential action is he faces the wrath of the people.
Right. But you
then thirdly, the Supreme Court ought to have decided this case with the agency that it was required. You see, this is brutal Freeman.
Brutal Freeman?
Yes. Look, I tell you,
but this precedent.
If you have a president, a future president, in the mold of Nana Addo Akufo-Addo, who knows that a decision of the Supreme Court will take 3 years, that president will act with impunity. So that's why the Supreme Court had to attach the urgency and attention to the breach of the Constitution that it has done. And future presidents, if they are minded to guide, and that is why we must take consequential actions on the president, so that future presidents will know that if they violate the Constitution with impunity, they will suffer the penalty.
So hold on, let me end it on this note. Martin, hello Martin. Hello Martin.
Yes.
Okay, so so Martin, there's a question I want to ask you, but before that I want you to deal with this. And the question I want to ask you is about the potential consequence that people are raising, that if this is the pronouncement, then the appointment that was made of the person who is in office now is equally unlawful and unconstitutional. So what is that person's locus? The present Auditor General, what is his locus? But the question before that is what Honorable Innocent Hussaini mentions. The delay. Who caused them?
Okay, Sam, I think to be fair to the Supreme Court, part of it is on them and part also of it on me. Yeah, so there's, when you file, there are processes. The AG will take some time to file, right? And the AG took, and also part is on the Attorney General, yes. So everybody, there's enough blame to go around. So
sometimes the Attorney General, it takes them forever to reply you.
Yes, I remember when we were doing the fight on disclosure, like this criminal disclosure, it took them 8 months. Yeah, the AG, I know they are constrained. The finance minister has to give.
Please don't make excuses for them. Don't make excuses for them.
You have always been anyway, we'll leave that. So this one, Sam, part of it on me, part on AG, part 2 on the court. Because when we come to mine, naturally this thing, I was doing it pro bono. I didn't charge legal fees. So though your spirit is willing, there are times, Charlie, you have to slow down this one and go and earn a living. So that's the truth of the matter. Yes. And then, so the lawyer is Ankuma did what he kept pushing. He said, look, Martin, either you charge fees or you do the work like you've charged fees. So every morning, on the platform.
The team actually got angry with you at a point.
Exactly. Yes, all that. Right. So we all did that. Also, let's remind this, now that we know that Supreme Court is very open to criticisms. You remember this case, the one about the pink sheet, election 2016, Kofi Benton's case, the Eshen versus Attorney General. When the Supreme Court wanted to do it quick, I remember that day, they even asked the lawyers. I think, Sam, you were also part.
No,
they should go into the, you were okay, no, Kofi Benton and Co. That, Sheshe, lawyer Kutampa, Kofi Benton and Co. Yeah, that decision is one of the greatest that we haven't celebrated much. The one on the pink sheet. They told them, the judges gave their chambers to the lawyers to go and sit down there, draft the issues, and come out.
That's
and they
right.
did. And then the court went on. So it tells you that when the court wants to move swiftly, the court will move. If for other reasons, the court thinks, it should not be that swift, it's for them. You say, yes. But as I said, for me, Justice Doche made it in your case, when he referred to the unanimous FC case, and he was very accommodative. So it means that, yes, we can reasonably criticize the Supreme Court because they need feedback, not very vicious and vitriolic. If we express ourselves in courteous words with decorum, they will be ready to listen. And Sam, let me add, because remember the context is that Professor Akufo-Addo, he withdrew his case. He fought the Supreme Court very strongly because he said, no, they have to decide it quickly. They have to decide it quickly. They have to decide it quickly. But when the court wasn't doing, then he went and withdrew his case. On this same
so your consequential reliefs that were not granted, remind us, what were they?
Wow. So let's see. We're talking about perpetual injunction. 1 second.
Right.
Let me read them out. So wanted a perpetual injunction to stop the president from ever doing that. But Sam, even before then, you raised a critical question, which I've been thinking about. Once they say the appointment is null and void, it means that the president has to go through the appointment process again. Oh.
Okay.
Yes, the B. Let's start with it. The B says a declaration that, and that was granted, it says a declaration that the purported appointment or designation by or on behalf of the president on 30th June 2020 of one Mr. Johnson Ekuamwa-Esiedu as acting Auditor General is void and of no legal effect, as the said appointment stands contrary to Articles 71B, 187.3 and 187 Clause 7 of the Constitution, as well as the second schedule to the Constitution.
And so this was granted.
The appointment of Johnson Ekuamwa-Esiedu is null and void. So it appears the president has to go through the exercise again. Yeah, once it's been declared null and void.
There was no order for his name to be expunged from acting as Auditor General for the period.
Okay, this one, we call it in law res ipsa. Res ipsa. The matter speaks for itself. It's very clear that the appointment of Mr. Johnson Ekuamwa-Esiedu is null and void. So the president has to start the exercise all over.
Thank you. That was on the lighter note. But my substantive question to end with you was the reliefs that were not granted. Share them with us again. The ones that...
Okay, so relief D. It says, 1 second. It says that on a declaration that on a true and proper interpretation of Article 71, Clause 1, 187, Clause 2, and 297, Clause A of the Constitution, the leave entitlement of the Auditor General is like his salary, a right associated with his office as an independent constitutional office holder, and does not constitute or give rise to an obligation which the Auditor General is duty-bound to assume, or else be compelled to do so at the instance and insistence of the President. Then E, an order of perpetual injunction to restrain the President or his agents from issuing or seeking to enforce on the Auditor General any directive that has a purpose or effect of commanding the Auditor General to take his leave or to surrender any of his powers or functions to another person. Then F, an order of perpetual injunction to restrain the President or his agents from designating or appointing any person as an acting Auditor General to exercise a constitutional power or perform a constitutional function of the Auditor General without authorization from the sole duly appointed Auditor General. And G, any other consequential orders that the court may deem fit.
So these were not granted because of the delay.
Yes, the court said they were moot.
Yes, they had become moot.
Yes.
Okay. Yes. All right, Martin, thank you. Yes.
Sam, one plea, 30 seconds, please. We are begging MTN. They should open our mobile money wallets. Our monies are locked up. I have been blocked. So many millions of people are crying. Please, they should open our wallets. Let's take out our money. Then they can take their SIM cards if they so wish. Because we are really suffering. Yeah.
I think there's a process that when you go to their offices, they are able to do and effect your payment to you. Right.
No, we don't need to go there. They should just open it. We don't need to go there. It will cost us too much.
Okay.
But it is a consequence of your failure to do it earlier.
It is your right not to also do it.
Very well.
Yeah. Thank you very much. And on the matters of the delays, and on this day, there were actually two cases that the Supreme Court unanimously pronounced against. And one of it was the one that was challenging the powers of the president to unilaterally suspend fundamental human rights and freedoms in the whole or a part of Ghana by the Imposition of Restrictions Act that was made by Parliament. And I remember you and I had discussions here, and we said that law was unconstitutional.
Yeah.
It doesn't pass muster. There's actually no timeline to that law. So what that law effectively means is that, but for this decision of the Supreme Court that has struck down that Imposition of Restrictions Act 2020, any president, any day, could invoke that law and restrict your freedoms, even though there's no coronavirus. It was not coronavirus-specific law. And that case was prosecuted by Dr. Justice Shram Sai, and the plaintiffs in that matter, as Martin was talking about, were Professor Akufo-Addo Etua, Dr. Sena Day Tutu, Felicity Nelson, Benjamin Darkon, Samson Ladia Nyenini, Golda Addo, Democracy Hub, and Democratic Accountability Lab. So it's been an interesting time in the Supreme Court, and also chiefs who have been endorsing candidates have also been told that that is completely wrong. It's active participation in politics, frowned upon by the Constitution. They cannot do that. They can praise the regime for the development they have received in their area, but they can now say vote for this man, vote for that man. Let's see how the Supreme Court continues with its jurisprudence in this direction going forward. Now let's move on to Asin North. A by-election has been declared there because of Jachi Kwesin's removal as an MP.
Also, we're not going to say anything about the imposition of restrictions?
No. It's not part of the subject for discussion.
All right.
Right. And we are looking at the questions of risk that the NDC may be taking, because he's still facing criminal prosecution, and they don't know how it will end. There are some who suggest that obviously that case will take a long time. It will go beyond 2024, and the NDC is hoping that they will win. Once they win, since prosecution is a political decision, they will simply go and file a nolle prosequi and get him out because they disagree. Tony Addo is an elder in the NDC, Dr. Tony Addo. He's joining us on the phone to share his views. You know that he doesn't speak only about the economic matters, but also matters of politics with sufficient, understanding, if you call it jurisprudential understanding of the issues. Thank you very much, Dr. Tony Addo, for joining us on Newsfile.
Thank you, Samson.
Great.
I must say that it's a pleasure coming back, hearing my voice again on Newsfile after more than 24 years.
Wow.
The first and last time was in 1999.
Right.
Yeah. But
okay.
Samson.
Yes.
I wanted to make a very brief comment on the Supreme Court judgment on the Domelevo case. I thought you called me for that too.
Please proceed.
Yes, very briefly. Obviously, the Supreme Court has come to judgment when time has rendered the matter consequentially functus, so far as Domelevo's right is concerned, and in fact, in several aspects of the matter relating to public interest. But I must say, with regard to what my friend Inu Sapuseni said regarding the impeachment of the president, Inusa, I think it's about time that we call a halt to some of our style of politicking. I'll urge you to read William Shakespeare's Merchant of Venice, where we had a distinction between puritanical concept of justice and pragmatic concept of justice. And I think this should be good for the future democracy of our country and inter-party politics. Another comment regarding Mr. Martin Pebu Esquire's comment towards the Constitution, the framing of the Constitution. It was not done to appease President Rawlings. Kwame Nkrumah never had any role in both the technical propositions nor the deliberations of the Consultative Assembly, of which I was a member, and I was also a member of the powers of government that considered the provisions concerning the presidency. Indeed, if it was to appease President Rawlings, we would have allowed the term of the presidency to be 5 years. But we hotly debated it, and it was limited to 4 years. Now, to the matter regarding the risk Christians face with the criminal prosecution.
The risk, that is, if any at all.
If any at all. What I want to observe is that criminal prosecution must be proven, or criminality must be proven on
beyond all reasonable doubt.
Beyond all reasonable doubt. That is the first one. Secondly, the prosecution must prove mens rea that he had criminal intention to commit the offense that he did. Thirdly, there is the factor that he had reasonable belief that what he was doing was right. Reasonable belief can vitiate guilt in criminal prosecution. And finally, there is the element of reasonable steps that he took to prevent his commitment of the offense. These are 4 principles of criminal justice that must be taken into account. That's all I have to say.
Okay. Dr. Tony Edu, thank you very much.
You're welcome.
Right. So those were rather deep and, if you like, very sober, reflections on some of the, issues that we have brought to and we are discussing. So.